to serve our
Imagine building a house for years, laying the foundation, raising the walls, putting on the roof, and then someone walks in, hands you a court paper, and tells you the house was never legally yours to begin with. That is exactly what happened inside Nigeria's political space on the 30th of April, 2026. And if you think this story is just about one party or one man, stay with me, because what the Supreme Court did that Thursday will echo all the way to the 2027 general elections.
Be removed by the Supreme Court agreeing that the order of status quo antebellum made by the Court of Appeal was unwarranted, had no basis to make it. It was unnecessary. But affirm that we should go to raise the question of jurisdiction before the trial court.
Let us start from the beginning, because this story did not start on April 30th. It started months ago, and it has been simmering quietly while many Nigerians were focused on other things. The ADC, the African Democratic Congress, is one of Nigeria's registered opposition parties, and for the past several months, it has been ripping itself apart from the inside. There were three factions fighting over who legitimately controls the party. Three different groups, three different claims, and the whole mess landed in court. At the center of it all is David Mark, a man who needs little introduction to anyone who followed Nigerian politics in the early 2000s. Former Senate President, Benue State power broker, a man with decades of political experience. David Mark and former Osun State Governor Ralph Aregbesola were recognized as the National Chairman and National Secretary of the ADC, respectively. But one faction, led by a man named Nafiu Gombe, went to court seeking to stop Mark and Aregbesola from being recognized as the party's leadership. They filed for an injunction, which is essentially a court order saying, pause everything. Nobody should act until we sort this out. And things quickly got complicated. Here is where it got really messy. The Court of Appeal at one point issued what is called a status quo antebellum order. In plain language, that means go back to where things were before this dispute started.
And the view of the Supreme Court was that the court that can make an order for status quo antebellum is a court that has proceedings pending before it. And since the Court of Appeal had correctly held that the appeal before it was an incompetent appeal, that was a complete abuse of process, there was nothing again pending before the Court of Appeal to which it can engraft an order of status quo antebellum.
And INEC, the Independent National Electoral Commission, took that order literally. INEC removed the names of David Mark and Ralph Aregbesola from its official portal. It announced it would not recognize any ADC faction at all. Effectively, the ADC became a party with no recognized leadership at the worst possible time. Protests broke out. ADC members marched on the INEC headquarters in Abuja, accusing the Electoral Commission of bias and demanding that its chairman, Professor Joash Amopitan, resign. Mark's faction went ahead with their congresses and national convention anyway, accusing INEC of political interference. And the legal battles escalated all the way to the apex court. But the ADC ruling was only half the story of that Thursday, because at the same time, the Supreme Court was delivering a second earthquake. This time, inside the PDP, which is, or was, Nigeria's largest opposition party. Here is what happened. Back in November 2025, a faction of the PDP, led by a man named Tanimu Turaki, a senior advocate of Nigeria, organized a national convention in Ibadan, Oyo State. They held it on the 15th and 16th of November. The convention produced a new factional leadership structure. But there was a serious problem. A federal high court had already issued an order restraining the party from holding that convention until certain conditions were met. The court order was clear. It was lawful. It was binding. They went ahead anyway. In response, aggrieved PDP members went back to court, arguing that the Ibadan convention was conducted in contempt, in outright defiance of a subsisting court order. The Federal High Court agreed. The Court of Appeal agreed. And now, on the 30th of April 2026, the Supreme Court, in a split decision of 3-2, also agreed. Justice Stephen Ada, delivering the lead judgment, was blunt. He said, and I am paraphrasing here, the disobedience of that court order is not disputed. What happened in Ibadan was a threat to the administration of justice in Nigeria. He went further. He warned that when political actors begin to treat lawful judicial processes as optional, the very essence of constitutional democracy is in danger. And then the court said, the words that ended it all: the Ibadan Convention is nullified, void. It never legally happened. Hours after